Hello, everyone. My name is Leah Fowler, and I am a research director and research assistant professor at the University of Houston Law Center's Health Law and Policy Institute. And joining me today is Professor Claire Horner, who is a professor at Baylor College of Medicine in the Center for Medical Ethics and Health Policy, and interestingly, also a clinical ethicist. And she'll be joining us today to talk about decision-making at the end of life. So, Claire, can you tell us a little bit about why these issues matter in the context of the COVID-19 pandemic?
Sure. So we've heard a lot about people who are getting very sick with coronavirus, this COVID-19. Often when they go in the hospital, they need to be on a ventilator. So if you get to that point of illness, being on a ventilator means that you can't talk. You may or may not be awake and able to answer questions for yourself. So it's really important to have a plan in place for people to be able to make decisions for you in the way that you would want them to make decisions when you're not able to. And another consideration is that we're hearing from a lot of people that they felt okay with COVID for a couple of days and then they got very sick very quickly. So there may not actually be time to do some of these things once you're already sick. So it's really important to plan in advance.
So what are the types of medical decisions that have to be made when you're incapacitated?
So it could be anything from as simple as, can we start antibiotics for this pneumonia, to should we start dialysis? Should we continue on with the ventilator? Should we insert a feeding tube if the patient needs that? So it can really be anything from small medical decisions to large medical decisions that may need to be made on your behalf.
So that's really interesting, and it sounds to me sort of like medical decisions. So why are these things that doctors don't just make by themselves?
Well, it's really important that patients are able to make decisions for themselves. They get to decide what happens to them. So doctors don't have the right to say, this is what we're going to do to you. You're always able to give permission for whatever medical treatments are being recommended to you. And for that reason, when you can't answer for yourself, we want to make sure that your autonomy is still protected. Your right to make decisions is still protected. And so we allow somebody else to speak on your behalf rather than assuming the physician can make the decision for you.
That's great. So if somebody is interested in either writing down or in some way conveying the types of wishes they might have, what steps would they need to take?
So first of all, I would say that you should choose somebody to make decisions. The most important decision you can make in advance is deciding who would speak on your behalf. And there's actually, the laws in Texas provide a hierarchy of people to make decisions for you if you haven't told us who you want to make decisions. And that's different for whether they're making routine medical treatment decisions, so something like antibiotics or maybe a simple surgery, to life-sustaining treatment decisions, whether or not to remove a ventilator or start a PEG tube. And so the people who are on that list are people who are related to you, your family members typically. It starts with your spouse, and then goes to your adult children. If not adult children, then parents, and then the nearest living relative is typically the hierarchy. And what's important is to make sure you have a conversation with that person that you pick to say what your wishes would be, whether or not you would want to be on a ventilator long term, whether or not you would want to be in a nursing home, whether or not you may want a feeding tube. And once you've had that conversation, if you feel comfortable doing so, I encourage people to do what's called a directive to physicians in Texas. And that's the Texas version of a living will. To be able to write down on a piece of paper, here's what I would and would not want. And it can provide guidance to your decision makers. It can provide guidance to your healthcare team, the people who are taking care of you, to give us a very clear indication of what your wishes are for your medical treatment.
That's awesome. And so if I personally don't want somebody who automatically falls in the hierarchy of people to make decisions for me to make decisions, how would I indicate a different person? And can it be somebody who's not related to me?
Yes, absolutely. So filling out a medical power of attorney, which is a legal document, is what you would need to do to bypass that hierarchy. So at the very, very top of the hierarchy is the person that you name on a valid medical power of attorney. And they are above everybody else in the order of priority. And especially if you have someone who's not a family member, say you have a neighbor or a best friend that you really trust to make your decisions for you, it's very, very important for you to fill out this document. And some people go to their attorney to fill out that document. Some people will go to their physician. But the way that you need to do it is to sign it in the presence of two witnesses, and there are certain requirements for who can sign as a witness, or to have it notarized. So there are some very specific legal things that need to be done to make sure that this is a valid document and your wishes are being honored.
So, in the age of coronavirus, how does somebody get a document notarized or get to be around witnesses? Is it possible to do some of these things remotely? I know that I saw recently that Governor Abbott issued an executive order to allow for video conference notaries in certain circumstances. Is that something that can happen for a medical power of attorney?
Absolutely. So there is a remote notary process that is possible where they can do notarization through video conferencing. So that is something that is available to you.
Awesome. Now, if I'm a person who is cohabitating with somebody that I can consider to be my spouse and I believe to be in an informal marriage, is that person going to be my spouse based on the statutory hierarchy, or do I have to designate them as my decision maker on a legal document?
That's a really great question, and it's a question that I get a lot. People will say, you know, we've lived together for 10 years, so clearly we meet the meaning of informal marriage and I should be the decision maker. Unfortunately, in Texas, the definition of spouse includes a common law spouse, but does not include a domestic partner. And common law spouse actually means something very specific in Texas. It means that, first of all, you and your spouse have agreed to be married right now, not that you promise to be married in the future. So if you refer to each other as your fiance, that's not a common law spouse. And if you agree to be married, you say, okay, from now on, we are now married. We are not going to go to the courthouse. We're not going to go through the formal process. We just decide to be married right now. And then you present yourselves as married to other people. So if you say, you know, this is my husband, this is my wife, you act as though you are married, present yourself as married to the general public. People close to you say, oh yeah, they're clearly married. That's an indication that you are presenting yourself as married. And finally, you live together and you kind of commingle your lives after you've made that agreement to be married. So there are actually very specific requirements that need to be met for informal marriage, and it's not just a domestic partnership. There are other states that recognize domestic partnerships that are not common law or informal marriages as being on the medical decision-making hierarchy. But unfortunately, if you are cohabitating or you're a domestic partner with an individual, and you're not legally or informally married under those conditions, then that person is actually not on the hierarchy at all, and they have no rights to make decisions. Now, that doesn't mean that as a clinical ethicist, I would absolutely ignore an individual who is the partner of the patient. You know, you likely know the patient the best, being the patient's partner. But unfortunately, the legal consent, the person who can actually provide legal consent, is not the domestic partner in that situation. So I always highly encourage people, especially in those kinds of scenarios, if they want their partner to be their decision maker, to fill out a medical power of attorney to make sure that that person has the authority to do so.
So that's really awesome information and I think really important to convey. But I often hear words like medical power of attorney and advanced directives talked about sort of in the same sentence. Can you talk a little bit about how these documents are different and why or if you need both?
Sure. So advanced directive is really the umbrella term for any document that you fill out to plan for medical decisions when you can't make them yourself. So they include the medical power of attorney, which decides who makes decisions for you. And it also includes the directive to physicians, otherwise known as a living will, that decides what decisions to be made for you. So advanced directive is really a more umbrella term governing those different documents. And again, one decides the who and the other decides the what.
That's great. And so one of the benefits I think of having somebody here to talk to us with your specific experience is as a clinical ethicist, you're there at the bedside when these things go wrong or the types of problems that can arise when these documents don't exist. I was wondering if you could tell us a little bit about those situations and any tips or tricks you've kind of figured out from your experience at the bedside.
Absolutely. So first and foremost, I would say if you do have an advanced directive, whether it's a medical power of attorney or a directive to physicians, make sure that you give a copy to your doctor, to your primary care doctor, to your cardiologist, to anybody who's involved in your care, so that they know that these documents exist. Second of all, if you have named an agent under a medical power of attorney, make sure that they have a copy of that document. So in the hospital, if somebody comes in and says, I have the authority under a medical power of attorney, unless they have the paperwork with them that shows that the patient named them the healthcare agent, we assume that there is no document in place. Oftentimes people will say, I'm the MPOA, and what they really mean is that they are the next of kin and have legal authority. There's actually different rights and responsibilities based on whether or not you're named as the healthcare decision maker under a medical power of attorney or just the default surrogate under the law. So it's really important for us in the clinic, in the hospital, to make that distinction. So definitely give a copy to your healthcare agent and make sure they have it and they can bring it with them anytime they need to show that they have the authority. And also, if you end up deciding that somebody else should be your surrogate decision maker, it can be really hard to pull back all of those copies that you've given out to your doctor or to your healthcare agent. Make sure that the right person has the right form. So if you've named a new agent, make sure your new agent has the new form and they can go in and say, look, here's the newest document. This is the one that we should listen to. I also think it's really important to make sure that you've clearly identified who you do and do not want to make decisions for you. I've seen many circumstances where there's a family member at the bedside who's making decisions, and then somebody else comes along, maybe another adult child, and says, this person has been estranged from the patient for a long time and shouldn't be part of medical decision making. It can be really difficult when we have family members who disagree with one another. I see this often with several adult children in a family that might disagree with one another. Perhaps there is a new spouse who's disagreeing with some other members of the family. And it can be really difficult to try to navigate that and still have the voice of the patient come through. So making sure that you're having those discussions, thinking through if there are any disagreements in your family, thinking through who is the best person to make decisions for you. That's really key to be able to plan in advance to make sure that we can minimize those conflicts when we need to really be focusing on you and what you need in your medical treatment.
So for somebody out there who's listening and thinks, I made these documents in the past, but my opinions, my thoughts, my relationships have changed over time. How do you indicate that one is no longer valid? And how do you make sure that the most recent one is the one that's most readily available?
So the way you can revoke your previous document is you can tear it up, you can draw through it, you can write on there that it's void, and you can fill out a new one, because the one that's dated later in time, so the newest one, is the one that's going to be valid. I have seen it happen where one family member will bring in one power of attorney and another family member will bring in one from a year later. So that confusion is easily resolved by looking at whichever one is newest, but it can be very, very difficult, especially if we don't have the new one, to be able to say, okay, is this a valid power of attorney or not? We assume it's valid unless we have a new one in front of us. So especially if you're naming someone else or you don't want the person that you named before to be your power of attorney, I highly recommend creating a new power of attorney, not just destroying it unless you've destroyed the only copy that you've made, just to make sure that there's not a copy floating out there that has outdated information on it.
That's awesome. And so the one remaining question I have is that these are really difficult conversations to have, and they force us to think about topics that are really difficult. Do you have any ideas or tips or recommendations for people who are just starting to think about these things for themselves or want to encourage family members to think about them?
Absolutely. So the idea behind these documents is to give you a voice when you've lost the ability to share what you want. And so ideally you want to pick somebody that you trust first and foremost, somebody who knows you, knows your values, knows your wishes, knows your preferences, someone who knows that, what you value. So there are some people who would say, if I could never garden again, I would not want to be kept alive on machines. There are other people who say, even if I were on machines and unable to get out of bed, if I could still see my grandchildren and interact with them, that would be acceptable to me. So having that understanding of who you are, your values, your goals, things that are important to you is really key for your surrogate decision maker. And second of all, I would say it's really important to pick someone you know can carry out your wishes. I've talked to people who have said, look, I love my wife. I think she knows me best. She loves me more than anything, and she knows exactly what I would want. But I know that when the time comes and I would want to have the ventilator taken off to be allowed to die, she would not be able to make that decision. Even though it's what I would want and she would know that's what I would want, it would just be too emotionally difficult for her. So that's happened sometimes, and people will say, I know that that's not the right person to make decisions for me, because they wouldn't be able to carry it out. So it's very important to think about that. Who can actually carry out your own wishes? So those are kind of the most key points I would say in picking someone to make decisions for you is, do you trust them? Do they know you? And can they carry out your wishes?
Well, thank you so much for joining us today. I know that I spoke to you in advance and we were able to pull together some resources that people might be interested in looking at when making these decisions for themselves. So I'm going to share those on my screen now so that everybody has an opportunity to see them. We will also make them available on our website. And this is the Houston Methodist Advanced Care Planning Guide that's available through Baylor College of Medicine Center for Medical Ethics and Health Policy, as well as 2 sites from the Texas Health and Human Services, one for medical power of attorney and one more generally for advanced directives. And finally, a resource from Respecting Choices that specifically deals with COVID. And thank you so much for joining us, Claire, especially to you. We're very grateful for your time, and we hope you're staying safe and well out there.